Good morning, I am Lakshmi. Today we are here to give presentation on business and corporate law. We will be using IRAC rule throughout the presentation. This case is related to the Martin, who is the employer of the company, he is the sales manager, and the issue of this case is, does the swimming pool company responsible for Martin Act? This is the issue, and the rules applicable for the issues are the essential contract, like agreement between the parties, considerations, and the create legal relationship are the rules of this case. And to while going forward, like application of law under the Act of Consideration, swimming pool company promised to pay bonus for sales, and Martin was promised to pay extra bonus from the company if he sells more contract with the people. But being the employee, he seems dishonest and unfaithful, because he didn't submit all the money in the bank, and he didn't go to the company policy, and Martin did something that was signed against the company law, which means that was against the legal law act. And the conclusion of this case is, like, the company, as being the employee of the company, the Martin should be charged of breaching terms and conditions and signed the client. And according to the contract, he need to be give some penalty and some kinds of charges from the company. And again, like, by using the IRAC rule for the second case of the same Martin. And in this case, like, Martin case, the issue was, like, can the company claim they are not liable for the Martin? It means that the company can be responsible for the Martin Act. Yes, because by using the rules from this case, like, Martin is the employee of the company, and under the Consideration Act, there must be company promise to pay extra bonus if he sell more contract, and the Martin also promised to sell more swimming pool to the other clients. But in this case, the Martin was, like, unfaithful. He was dishonest with the company. He did totally against the company law and the legal law act. That's why in the applications, it seems like there is no intention to create legal relationship, because from the beginning, Martin was not doing the act according to the company act. And the conclusion of this part, like, swimming pool cannot must be liable for the Martin Act, because he is the employee of the company, and the company should need to investigate and do survey about the Martin Act. And as being the company employee, the company should need to be liable for the Martin Act. And this is my part, and for the rest of my part, I would like to invite my another member, Sujata, for the rest of my presentation. Thank you.
Thank you, Lakshmi. I am Sujata. Let me begin my part from chapter 2. So, issue of the case is evaluate the liability of Martin for his action to the employer, and rules is, in this case, there is a question raised that whether Martin must compensate the amount of damages that company must pay to the customers. However, there is no well-established law for reclamation of damages by an employer for the employee, though there is other method to deal with such situation. The application would be like, Martin have used the money of the company for his personal benefit, hence Martin is liable for his action to the employer. He's failed in performing proper employee's duty. Firstly, being an employee of a company, his duty is to provide proper suggestion to the customer, but he did not provide correct information. Secondly, as per the promise made with the customer, he is not allowed to make different construction than he had promised. According to the law, the company can be charged breach of contract against Martin. And the conclusion of this issue is, he has intentionally used the money for personal benefit which does not belongs to him. This is the case of offense of fraud. Moving to the next issue, has Martin breached any law for planning to set up his own business? And the rules would be like, although he failed to deposit the received money into company's bank account, he kept certain amount for his personal benefit. He had cheated to the company. For committing such an act, he can be held liable. Application is, for the breach of contract signed between Martin and the company can even prosecute him, claiming damages caused by him. conclusion for this case is, being an employee of the company, Martin failed to act in good faith. Martin did not perform his job as per the contract signed between an employer and employer. The swimming pool company might have dismissed him for the damages and for the breach of contract of loyalty. Thank you, and the remaining part will be continued by my friend.
For the end of chapter 2, and now I'm going to start the chapter 7 and the case. We have issue for the question A. Lucy Simmons and Co are jointly carrying a partnership, and under this there is rule like under common law rule, there is intention, agency and sharing of profit and loss indicates the existence of partnership, whereas under the statutory rule there are 3 rules as follows, which shows the existence of partnership. Rule number 1 is co-ownership, rule number 2 is sharing the gross returns, and rule number 3 is sharing of profit and loss. And for the application part, under the common law, there is no intention to be a partner between Lucy, Co and Simmons, as a court do not see the written agreement between them. Also their action shows that they do not actually pursue a partnership. There is no proof of each party acting as an agent for other party, and Lucy developed separate business relationship with Lucy Co clients and on extra income, whereas Simmons purchased industrial right and more without informing Lucy and Co. Similarly, based on the statutory law, they do not carry a business and mutually, as Lucy and Simmons has their own private motives to gain profit, and there is no sharing of profit between them. And for the conclusion, based on the Partnership Act of Common Law and Statutory Rule, court do not see the existence of partnership between them. Although the Simmons Co and Lucy are creating a partnership business, they do not intend to be a partner. Lucy and Simmons has their own private motive to earn extra money, and they do not share the profit. Therefore, Lucy, Simmons and Co are not carrying a partnership. For the part B, for the issue, Lucy and Simmons and Co are liable for purchase of right and more if they are partnership, and for the rule act under the Partnership Act of Journal Partnership, liability of his partner is unlimited. Under the application, Journal Partnership in Partnership Act defines that each partner is liable for the debts and liabilities of firm. Lucy and Co are liable for the purchase of right and more from Fast Court, although they are unknown about the order, and because every partners of the firm in partnership are equally liable for its transaction, debt and liability. For the conclusion, under the Partnership Act of Journal Partnership, Lucy and Co are liable for the purchase of right and more because they are carrying a partnership. Fast Court can claim money from for the right and more, although Lucy Co is operating under the laws. All the partners are liable to pay Fast Court bill through Lucy Co assessed. If not sufficient, then Fast Court will get paid through partner who has a great portion of assess. Thank you. Now that part C and D will be explained by our friend Ha.
Thank you, Dan. So my name is Ha. Today I'm gonna talk about the C and D. The issue for C is the Lucy breached the partnership by carrying out her weekend work, and the rule is general partnership of partnership stage actual and parent authority liability of partner to person outside the firm. The application for this one, Lucy earned money through developing separate relation with Lucy Co clients by removing their charge on the weekend. Customer thinks that Lucy has authority to act on behalf of Lucy Co and they deposited in her private account, while the other partners, Simmons and Co, are unknown about this fact. And in conclusion, by analyzing on the fact that Lucy takes an authority to act on the behalf of Lucy Co by developing separate business relationship with their clients. Hence, Lucy breached the partnership duty. The issue in fact, how could Fast Court recover who the individual are behind that business? And the rule of the law is every business required to have the separate tax file number, name, and Australian business number for all business dealings. Application of the law. This will provide information about the business name or who are office holder of the company. In conclusion, if needed, both common law and the Partnership Act have rules to assist the court when deciding whether or not business relationship continues a partnership.
And now I'd like to continue with the chapter 7, starting with the issue. We have what effect will same use debt have on the partnership. As per the general rule, every partnership is dissolved as regard all the partners by the death and insolvency of any partners. And the Partnership Act 1891 will be applied in case of no agreement between the partners. With application, partnership agreement will have to decide what will happen on the death of the partner and the rights and duties in such situation. However, in absence of the partnership agreement, the Partnership Act, in particular state or territory, will be applied to decide what will happen in the business. As a conclusion, since there has no partnership agreement and due to insufficient fund to pay for the ride and mower, the partnership will be dissolved due to the death of same use. Also, the Partnership Act in the state and territory will be applied to decide what partnership will be formed in the future. Moving on to next issue, we have how will Lucy and Co determine what is partnership property and how will the partnership property be used to meet the Lucy Co's losses. Now, if you look into the rule, the partnership property comprises property and rights and interests in property originally brought into the partnership or acquired, whether by purchase or otherwise. Hence, as per the application, in determining whether a property belongs to a partnership or not, a court will look into various factors, such as if the partnership funds were used for the partners or property for the use of the partnership. The court may also look into how the property is entitled. Moving on to the conclusions, since the industrial ride and mower were purchased in the name of the Lucy Co, it can be considered as partnership property. If the partnership is dissolved after the death of the same use, the partnership property must be realized and arrangement for the payments of the partnership debt must be conducted. Distribution of the assets must also be done. Hence, it can be used to pay the losses of Lucy Co's. Then after, any surplus assets can be divided among the partnership responsibly after deducting what may be owned by the partners in the firm. Thank you.